What I want to talk about tonight is, as Xavier mentioned, the recent case. And after last week's decision in the New South Wales Supreme Court, it might seem incongruous to be discussing the presumption of innocence in relation to former New South Wales ministers Ian MacDonald, Eddie Obeid, and Obeid's son Moses. The reason's pretty simple. Justice Elizabeth Fullerton decided that all three men are guilty of a conspiracy in which it was agreed that MacDonald had engaged or agreed to engage in misconduct in public office. So unless there's an appeal that overturns that verdict, there is nothing to presume. All three have been found guilty after a trial whose fairness has not been questioned. It is, however, worth considering what exactly happened in this case, because it highlights what I think is a structural flaw that had the effect of forcing the judge to delay this case and abandon her plan for a jury trial. The starting point for such a trial is that the onus rests on the prosecution to overturn the presumption of innocence by proving guilt beyond reasonable doubt before an unbiased decision maker. However, Justice Fullerton was confronted with public statements by the media and very senior political figures that, unless addressed, would have threatened the fairness of the trial by influencing jurors. The blame, however, should not rest entirely with the media and politicians. Much of the threat to the fairness of this trial can be traced back to the adverse consequences of the New South Wales Parliament giving less weight to the interests of criminal justice than it gives to publicising the work of its Anti-Corruption Commission. That's the effect of the ICAC Act. The New South Wales Parliament has given the Independent Commission Against Corruption a statutory instruction that has the effect of encouraging it to publicise its activities through public hearings and public reports. It has not, however, provided a statutory instruction to ensure that this does not undermine the fairness of foreseeable criminal proceedings. The Commission, therefore, was doing what it was told to do when it conducted sensational public hearings in 2012 and 2013, at which MacDonald and the Obeids were accused of wrongdoing and referred to the Office of the Director of Public Prosecutions. That referral shows that ICAC knew criminal proceedings were likely. But the same ICAC report that mentions the referral also outlines the accusations that formed the basis for much of the adverse pre-trial publicity that so concerned Justice Fullerton. The assertions of wrongdoing that were made at that ICAC inquiry were republished on Twitter 6 years later by a leading journalist just days before a jury had been due to be impanelled. This was one of the factors that Justice Fullerton described as a journalistic frenzy that persuaded her to impose a stay on proceedings in order to protect the fairness of the trial. ICAC's 2013 public hearing was the main source of much of the adverse pre-trial publicity that led to this delay, but it was not the only factor. Eddie Obeid and MacDonald, both former Labor ministers, had been to prison on unrelated matters, and at the time of the stay order, ICAC was running an unrelated inquiry into corruption inside the New South Wales Labor Party. So when politicians and the media conflated all that, which is what politicians and the media frequently do, they gave new life to the original report about MacDonald and the Obeids, and that is what Fullerton feared would derail the pending jury trial. In retrospect, the way the media and certain politicians conducted themselves in the lead up to this trial is best described as unwise. But as I've said, they should not take all the blame. Consider the role of ICAC. Most lawyers would be aware that this commission is not a court. It's a standing royal commission whose findings have the status of unproven accusations. The rules of evidence do not apply, and the merits of its findings are not subject to appeal. But because it adopts the outward appearance of a court, as well as the formalities of a court, many in the media have mistakenly treated its reports with unearned deference. That inevitably helps mould community perceptions about those ICAC considers to be corrupt, which is exactly the outcome that ICAC is under statutory instruction to achieve. To put this into perspective, try to imagine a situation in which police are told by Parliament to abandon the rules of evidence and open their interview rooms to the media in order to make the community aware of what the police consider to be wrongdoing. To ensure the views of police are taken to heart, imagine if Parliament provided no way of testing the merits of police reports, required the police to publicise the results of their investigations, and even tabled them in Parliament. And then try to imagine the impact that would have on potential jurors. That, however, is how ICAC operates. The Commission's power to hold public hearings is contained in Section 31, subsection 2 of the ICAC Act. This has the effect of requiring the Commission to balance the public interest in exposing corruption against the public interest in the privacy of those concerned, as well as any undue prejudice to their reputations. Nowhere in this provision is there any mention of the one factor that should take priority. It does not require ICAC to take account of the possible adverse impact on future jury trials. Instead, the decision-making process set down in Section 31, subsection 2 is essentially a balance between exposing corruption and protecting the privacy and reputation of individuals, that is, corrupt individuals. In other words, it's not much of a balance at all. In practice, the impact on future trials does not seem to figure in the Commission's thinking on when to hold public hearings. Instead, it seems more interested in its own goal of exposing wrongdoers. That's what the Act tells it to do. This can be seen quite clearly in the report on MacDonald and the Obeid's that was prepared by former ICAC Commissioner, the late David Ip. That report from the inquiry known as Operation Jasper explains why a public hearing was considered appropriate. It says, the Commission concluded that the seriousness of the allegations and the public interest in identifying the facts of what had occurred and exposing any corrupt conduct outweighed the public interest in preserving the privacy of the persons concerned. It's very closely related to the words of the Act. When Commissioner Ip wrote those words, it was foreseeable that his findings of wrongdoing might well result in a jury trial. Yet the impact of prejudicial publicity on the fairness of subsequent judicial proceedings is not a factor in Section 31(2). He was not required to take that into account. So how did this play out? Last week's judgment by Justice Fullerton concerned events that took place up to 14 years ago and had been made known to ICAC 10 years ago. The Commission received a tip-off in February 2011 and did not produce its Jasper report until July 2013. That's bad enough. Then what happened? The prosecutors at the Office of the Director of Public Prosecutions did not produce an indictment until 4 years after that. But to be fair to the prosecutors, once they received ICAC's material, they effectively needed to start again, checking that everything had been properly obtained in a way that complies with the rules of evidence. They were preparing a case for a court, not for a commission. In 2019, as pre-trial hearings were underway, there was a wave of prejudicial public discussion about the Obeid's and MacDonald. This led to the judge taking increasingly strong measures to protect the integrity of what she clearly hoped would be a jury trial, at that stage anyway. First, there was a suppression order. Then she asked the media to take down stories from the internet about ICAC and Moses Obeid. And finally, after pushing back this long-delayed trial for another 5 months, the publicity had not abated, so she presided without the assistance of a jury. In other words, she had to change her process because of something that happened at ICAC. The question to consider is whether these measures would have been necessary if ICAC had been required to give priority to criminal justice instead of publicising its own efforts. Such a change in priorities could have required ICAC to give the DPP its files on the Obeid's and McDonald as soon as it had enough material to show that serious misconduct had taken place or appeared to have taken place. It might also have required the Commission to truncate or even forego a public hearing in order to ease the risk of undue influence on a future jury and allow an indictment to be prepared much earlier. In a rational world, it's difficult to see why publicising unproven allegations was considered a higher priority than bringing McDonald and the Obeid's before a court. Yet that is how the system works in New South Wales. The statutory duty under section 31, subsection 2, to expose corruption sounds admirable, but it's no less admirable than the goal of exposing homicide or sexual assault or any other multiple crimes that exist on the statute book. And this case shows that it can come at a cost, that statutory goal can come at a cost, both in delays in bringing these men to court and the risk that the lasting impact of publicity generated by ICAC could undermine the fairness of a jury trial. Those costs need to be weighed against the benefits or apparent benefits of the Commission's public hearings and reports. It needs to be kept in mind that public hearings are generally preceded by secret private hearings where the key issues are covered. This was apparent when Premier Gladys Berejiklian was brought before a public hearing in October last year and asked about her private life. The transcript shows she made the point several times that many of the Commission's questions had been asked and answered in an earlier private hearing. This means there is at least some degree of duplication between the Commission's private and public hearings. There can be no doubt that the public hearings and report in the McDonald and Obeid case did have a lasting impact. But the issue is whether the justice system should be required to bear the cost of dealing with that impact. Consider what happened during the pre-trial hearings. On March 19 of 2019, Moses Obeid asked Justice Fullerton to delay the trial until media outlets, including Google and Yahoo, had removed information on the internet concerning ICAC and himself. Had the judge agreed, it would have embroiled the Supreme Court in a dispute with all the organisations named in Moses Obeid's notice of motion, the Sydney Morning Herald, the Daily Telegraph, the Australian, as well as what he referred to as other newspapers and media outlets, in other words, everyone. On April 1, media lawyer Peter Bartlett of Minter Ellison, who has advised The Age for decades, told me that if this order were granted, the media would appeal. He made the point that such an order would have little utility given the nature of the internet and would also impose unnecessary costs. Fullerton had already expressed doubts about whether her court had jurisdiction in order Google and Yahoo to comply with the proposed orders. She was, however, clearly concerned about what had been reported in the past about the Obeids and ICAC, and we know that from what happened next. Instead of issuing an order, as Moses Obeid had sought, the judge had lawyers from the Office of the DPP write to media outlets with a request, not an order. That letter was signed by Hugh Baker SC, who was Acting Deputy Director of Public Prosecutions, and was sent to media outlets on April 12, 2019. It points out that the judge had issued a suppression order on April 3, 2 days after Moses Obeid's notice of motion, covering any evidence in the forthcoming trial and any information concerning the evidence. It then says, Justice Fullerton has asked the Director to write to the media to request that in the context of the pending trial, that any historical references to the circumstances in which Moses Obeid came to be charged and implicated in the alleged conspiracy be taken down. In other words, the judge was concerned about what happened at ICAC and the report. What happened next must have driven Justice Fullerton to distraction. On September 30, 2019, a jury had been due to be impanelled, but just 3 days earlier, the judge found it necessary to stay the proceedings until February 3, 2020 because of prejudicial publicity. That meant the case would not come on for trial until 13 years after the conduct that gave rise to the criminal conspiracy involving two men who have been ministers in the previous New South Wales government. As soon as that stay was ordered, the judge imposed a suppression order so that only the barest details could be reported based on a statement that was issued by the Supreme Court, not the judgment itself. But that judgment, the eighth in a series of interlocutory rulings involving McDonald and the Obeids, has now been published on the Supreme Court's website. It is well worth a read. It reveals a level of frustration, not just with what Justice Fullerton described as journalistic frenzy, but with contemporary remarks about McDonald and the Obeids that had been made by Premier Gladys Berejiklian and Prime Minister Scott Morrison. The Sydney Morning Herald was described in this judgment, or is described in this judgment, as grossly irresponsible for publishing an extract of a book by Kate McClymont that referred adversely to Eddie Obeid's past conduct and described him as the architect of skullduggery in the Labor Party. That extract was published in the Good Weekend magazine on September 14. The jury had been due to be impanelled on September 30. On August 30, a little earlier, Fullerton's judgment shows that McClymont tweeted a link to one of her stories from 6 years earlier about the accusations that emerged at the ICAC inquiry, the same accusations that were to be dealt with by the jury during the trial. Fullerton reserved her strongest criticism, however, for Berejiklian and Morrison, who had made separate remarks about Eddie Obeid and Ian McDonald just weeks before the trial had been due to start. But for the suppression order, the judge's criticism of the Premier and the Prime Minister would almost certainly have generated even more adverse coverage of these men. The Obeids and McDonald I'm talking about here. This is what she said. Neither the Premier of New South Wales nor the Prime Minister of Australia is properly to be regarded as simply a politician whose views might not be deferred to. To the contrary, their views might be thought to carry weight even if expressed in the context of party political rhetoric. Were I persuaded, and I am not, is what she added, that the Prime Minister of Australia or the Premier of New South Wales made the remarks attributed to them aware that the criminal trial of Edward Obeid and Mr McDonald was pending on a charge that alleged an agreement between them that Mr McDonald would willfully misconduct himself in public office with the intention of benefiting Edward Obeid and his family, including in that connection his son Moses Obeid, that conduct would be, at the very least, reprehensible, given the obvious potential of those remarks to undermine the right of the accused to a fair trial according to law. There are two main difficulties with the New South Wales approach to ICAC. The first is that it appears to assume this commission will never make a mistake, and there is, therefore, no need to provide a merits review mechanism. To that extent, ICAC is presumed to be like the Pope, infallible. The second difficulty concerns the presumption of innocence, and this is the more egregious. If a narrow view is taken, such as that in Article 11 of the Universal Declaration of Human Rights, the presumption is confined to criminal proceedings. But the Universal Declaration has only existed since 1948. It is not the source of this doctrine, it is merely declaratory of an idea that was already part of the history, culture, and common law inheritance of this country, the fair go. Nicholas Cowdery, who was a former DPP in New South Wales, has argued that Magna Carta, which was sealed in 1215, provided inspiration and support for progressive development in governance worldwide, including the presumption of innocence, equality before the law, and due process. In 2015, Cowdery endorsed the view of Sir Gerard Brennan, a former Chief Justice of Australia, that Magna Carta lives in the hearts and minds of the Australian people and is a set of ideas that has been brought to Australia with the first English settlers. In the English common law system, it is the touchstone of the rule of law, Cowdery wrote. Brett Walker SC explained the concept at a recent online conference run by the Rule of Law Institute. He gave the example of those facing criminal prosecution who had the benefit of the presumption of innocence but were not entitled to be regarded by others, such as prosecutors, as being in fact innocent. This is what he said. This is what Walker said. In short, the presumption of innocence involves an open mind about the outcome of a trial, but not the magical thinking that says that until a person is convicted, they were innocent and should never have been tried. Guilt of a crime in our society, at least, is only ever of conduct that was criminal at the time it was committed. And if you have been guilty as a matter of English since you committed the offence, and you have been guilty of the offence since you committed the offence. So I would very much like, this is Walker, I would very much like to see the presumption of innocence understood as being a cardinal principle of the fairness and propriety and decency of the criminal system that calls for accusations to be made good rather than defences to be demonstrated. But I would very much like, this is Walker again, I would very much like it to be banished from discourse concerning people who are the objects of criminal process. They are presumed innocent. It doesn't mean they are innocent. There's another view, that's the end of his quote. Now, there's another view on the presumption of innocence, and that is that it applies generally, not just in criminal cases, and requires those making an assertion to discharge the onus of proving their case. But on either view, the starting point in criminal justice is that a fair trial takes place in a court, not a commission, and requires the prosecution to prove guilt beyond reasonable doubt before an impartial decision maker. In our system of justice, punishments can only be imposed by courts, not commissions. And people who come before courts in the expectation that their conduct will be judged according to law. But in New South Wales, it's becoming clear that ICAC has been empowered by the state to punish people by damaging their reputation, including those who are likely to come before a jury. That cannot be beneficial for justice. It took a public statement by Lloyd Babb SC, the current DPP in New South Wales, to ensure the true nature of this commission could no longer be denied. Babb was refreshingly frank in July last year when he made a formal submission to a parliamentary committee that says Parliament intended ICAC's findings to have an adverse impact on the reputation and lives of the people concerned. He accepted that this was a punishment. And this is a direct quote from his submission. An adverse finding can have significant effects on a person's reputation and life. Such effect was clearly intended by Parliament, both as a deterrent and a form of punishment for undesirable conduct in this public sphere. Any reputational impact is a necessary and intended consequence of ICAC exercising its functions to expose and prevent corruption in the New South Wales public service. And I'll leave it there, But the bottom line is the function of ICAC after this case, after the Abeeds and McDonald, needs proper scrutiny. 14 years is far too late to wait to bring these people to justice.